Hello, everyone, and welcome to Client Contracts Reimagined. I'm going to get my screen shared with you in just a moment. So welcome. Please say hello in the chat. If you are here live with us today on this lovely day in November, let me know where you are tuning in from. Would love to hear from you. And we should have our screen shared. There we go. All right, great. Looking good. Let's see. And once again, welcome to Client Contracts Reimagined, transforming contracts into tools for business success. My name is Yasmine Salem Hamdan. I'm a business and intellectual property attorney. And this training was inspired by the business owner who works with clients one-on-one and is planning on signing new clients in the new year in 2025. So if that is you, you are in the right place, my friend. And we are going to get into some things that are have the potential to change your entire experience in the new year in 2025 as you work with clients, as you sell online services, digital products, if you are selling corporate consulting, personal coaching, downloadable products, templates, hosting events like this one where you are educating your audience and sharing value with your audience to help them improve that area of their life or business or whatever it is that your work is related to. Preparing your contract and preparing yourself is one of the best ways to present your business and your services with confidence and give your clients the opportunity to have confidence in you and in your work as well. So a little about me, as I mentioned, I'm a business and IP attorney. I'm based in Dallas, Texas. I am also a consultant on digital business models and digital strategy, and I love to help my clients legally protect everything that they're working so hard to build. You are probably spending hours and hours and hours creating resources for your audience, for your clients. You're creating intellectual property assets that you might not realize at this point are intellectual property assets, but in fact, they hold value. And so I've dedicated my career to working with small business owners, helping them to get legally protected, even if you don't have thousands and thousands and thousands of dollars in capital or investment to spend on legal services working with a lawyer and a law firm one-on-one. As I know, and as many business owners know, that can be, out of the budget in the first few years of business. And so, like I said, I've dedicated my career to helping small business owners get access to legal resources and information like that, of which I'll present today in today's live session, and also through our resources at coachesandcompany.com or downloadable contract templates that are nowhere near the cost of time and money required to hire a law firm to custom create contracts for you. So more on that later, but in the meantime, we're going to talk about the power of proactive protection before we get into the specific contract clauses that I encourage you to explore and make sure that you're conducting an audit of your own client contracts before the new year begins. I'm also going to share access to a client contract audit checklist with those of you who are here live, so you can expect to receive that. I'll likely drop a link here in the chat towards the end of today's session, and then those of you that attended live will also receive an email with a link to the Google Doc that you can make a copy of and conduct your own client contract audit. Okay, so if you're here, you probably fully recognize the importance of written contracts in your relationships and in your business, and that they are the foundation of your business, and that relationships are the foundation of your business as well. And without relationships, you really don't have a business. And so putting those the terms of each and every relationship into written words and in writing so that people have the opportunity to understand what your policies are and to agree to them can totally transform the way you experience your business every day and the way your clients experience your business. And so when it comes to taking these steps, I fully recognize that, you're probably not a lawyer. You probably didn't go to law school, and that's okay. You shouldn't have to go to law school to have a great business. You shouldn't have to go, hire an expensive attorney. You shouldn't have to do that to have a legally protected business that you can confidently put forth to your clients. And so there's so much power in taking action early on and investing in your business in a way that protects it, and that increases your confidence, how you present yourself to the client. And like I said, gives the client also a chance to have confidence in you and have trust in you, because when we don't have solid contracts in place and we're not clearly laying out the terms of our relationships, that can leave clients feeling like, okay, I don't know exactly what to expect. It doesn't feel like they're exactly certain of what is going on. And so whenever you clearly lay out, okay, if this, then that, if this, then that, I already recognize and anticipate all the potential scenarios that could arise with my client. You know that better than anyone else. And so laying that out in a written agreement is, in my opinion, I will, argue it I am a bit biased because I work in the world of contracts, but it's only because I've seen the impact of having a strong contract with your client and how that can, create trust and confidence, which is truly the foundation of any professional relationship. So I encourage you to be proactive. Don't wait to be reactive. It's always more expensive to be reactive and do damage control and clean up a legal mess. Whereas being proactive, it requires you do a little bit of due diligence early on, but you will be thanking yourself. You won't be kicking your past self over what you didn't do. Instead, you'll be thanking yourself for what you did do. And so let's get our contracts ready for 2025, shall we? So we'll talk about 3 essential policies to protect your business, and that you should consider including in your client contracts. These are clauses that I have seen work with clients and with customers of Coaches and Company. And I've heard stories about how I've experienced these stories myself as a professional service provider. I provided legal services for many years, and as well as consulting services. And many of my clients have also experienced similar situations, like how to handle client delays when you're waiting for feedback from a client and the project is supposed to be moving along and making progress. You're possibly approaching the next milestone. And all of a sudden they go radio silent and you don't know what happened. How do you handle those situations? Well, your contract can lay out the workflow, if you will. If this happens, then this is what happens. And this is how we handle it. Next, we'll talk about securing permissions to move forward. So there are a number of things that you want to make sure you get on the same page as your client on, as far as and we'll talk more in depth, of course, once we get to that point of today's session. But this includes using their likeness and using their project as a part of your portfolio. And also, if you want to create a case study or feature their testimonial, like what kind of permissions should you get? And should you wait until later to get those permissions? Or is this something that you can just collect in your initial contract? And then finally, we'll talk about protecting IP. Protecting your intellectual property. And this is protecting all of your creative works that, again, you're working so hard to create and is worthy of protection. Again, even if you can't hire a big city law firm, with thousands of dollars on retainer to help you get it legally protected, there are still ways that you can take steps to legally protect what you're creating and be proactive so that you're not having to hire a lawyer to do that damage control later on. Okay, I'm seeing some of y'all in the chat. Veronique from Ampersand Workspace. Hello from Aurora, Colorado. Hello, hello. It is my pleasure. Thank you for being here. I'm so happy to host this. Prathima, hey there, from California, social media strategist. Lovely. Welcome, welcome, Prathima. Ain, a holistic beauty specialist. Love it. With Ain Artistry. Love it. Judy Z. Hello, Judy. Life and love coach in San Diego, California. I love San Diego. It's one of my favorite places on earth. Well, welcome, everyone. Thank you so much for being here. And we're just getting into the good stuff. So buckle up. And if you are not taking notes, I encourage you to open a fresh Google Doc and just jot down some notes that stand out to you. Of course, this is, and it should go, I would hope that it would be clear, but of course I always have to say it, and I always include, and you'll see in the checklist as well, there is a disclaimer that states that this is not personalized legal advice. This doesn't substitute personalized legal advice, of course. Well, I'm so glad that you're here and so happy to have you here live with me, or if you're catching the replay, it is an absolute pleasure and honor to have you joining me and learning this information to support your business and help propel you in 2025 and beyond. This doesn't substitute personalized legal advice. And so if you do need personalized legal advice, or if you're unsure if this information is relevant to your situation, I encourage you to consult one-on-one with a lawyer in your local jurisdiction. Local jurisdiction is important because every jurisdiction has its own laws on the books related to business and commerce. And so make sure that you are connecting with a lawyer in your local jurisdiction. And we'll talk more about that as well. Okay, so let's see. Okay, so the first thing that we're going to talk about is keeping your projects on track when clients go silent. So I remember years ago, I had a client who, she was a very talented designer and consultant, and she was working with a client of hers. And it was a 6-month contract. It was a 6-month project. And so they had agreed to payment on a milestone basis. So it was let's say every 4 weeks, she was receiving payment, for example. And at some point, about a third of the way through, her client just went ghost. She just was not hearing from the client anymore. They were not replying to her emails. She was trying to reach out, and it was during a period of feedback and revisions. And so she was waiting to receive the client's feedback so that she could move on to the next milestone, and was just unsure of how to proceed because she couldn't proceed without their, participation and response and their responsiveness, and they were being unresponsive. And so she and I spoke and worked together to improve her contract so that she would actually have a pathway to resolving that issue in the event that a client does just disappear. And what we ended up creating was a pause clause that she could include that stated, if there was, a situation where the client was non-responsive for X number of days, that the contractor or the company, in this situation that I'm describing, my client that I was speaking with, she would be able to invoice for the work completed to that date and then have the option of pausing the contract. And then if the client wants to resume it at a later time, there would be a resumption fee, because of course there's work and resources involved in winding down a project and then bringing a project back up to speed. That requires time, money, and team power. And so that is totally reasonable for you to include in your contracts, especially if you find that you are working with clients on an extended basis. I would say longer than 2 months, I would say, generally speaking. The longer the project is, the more opportunity there is for a client to, just be non-responsive. And that can affect, that can create an effect of, delay on other projects and your own work timeline as a business owner and as a professional service provider. And so this is a way for you to protect yourself as a business owner and account for those situations where the client is not being responsive and you're having to continually modify the timeline for the project. So let me know in the chat if you've ever been in a situation like this. Have you ever found yourself with a client who is non-responsive? I would love to hear from you. And welcome everyone who has joined. Yes, so this is a fairly common situation, and I would say it's something to be anticipated and not necessarily expected for every client engagement. But when we anticipate these situations and account for them in our contracts, it puts us in a position of power in a positive way. It puts us in a position to make decisions and declarations that are backed by an agreement that both parties agreed to. And so including a contract clause like this, I'm not saying that this exact example, this is just here as an example I wanted to provide. And let me scroll up a little bit so you can see the full example clause. You might even want to consider, because in those situations, maybe you find yourself working with a client, they're being non-responsive. Maybe this has become a pattern and you simply want to end the contract at that point. You can also contract for that. You can include that in your contract and specify that you'll have the opportunity to just, terminate it. And then if they want to restart it, you need a new written agreement, which I think could be totally fair depending on the circumstances of your situation. Let's see, we have a comment. Judy says, yes, I had one client completely ghost mid-coaching contract. She paid up front, so there was no lost revenue, but was unresponsive and never resurfaced. I never knew what happened to her. Kind of sad, honestly, but very realistic. Totally understandable. I mean, I have actually been a client that went non-responsive for a period of time many, many years ago. I would say this was maybe like, I don't know, maybe 7 years ago now. I had a project with a designer, and we were working on a contract together. We were working on a project, and then I became ill, and then I had because I still had my business that I was running, and you know my plate became very full, and I was behind on communications and on my inbox. And at the time, I had some support in my business, but I had limited support, and so I can certainly see how it could happen. I think that, there's a courtesy, of course, of communication. And as soon as I was able to, and it wasn't for months and months, and of course, like eventually I did reply. But I can easily see how a client could find themselves in a situation where you are not responding within the window of time that the provider is expecting for you to respond. And, every single situation is different. No two situations are the same. And so any one fact of a situation can, change everything. For me at the time, I wasn't in, breach of a contract, and it was, I replied within a reasonable window of time. I would say it was, beyond what was expected and what we had intended. However, sometimes clients just do not reply at all. And so if they have paid up front, and you're not, at a loss of revenue, or, standing there holding the invoice, and you have an outstanding invoice, that's a different situation than if you, find yourself needing to bill for work that has been completed, or if there was revenue that you were counting on because you had maybe hired subcontractors to fulfill on this project, which is also a common situation. So you might want to be able to, call the invoice due at that time if they've been non-responsive for a certain period of time. So thank you, Judy, for sharing that story and your experience. I think that is more common than we think, and hopefully you don't face any situation like that again. But yeah, it's something to be prepared for. And I think it's a great practice too that Judy brings up, is collecting your payment upfront for services. If you are going to be reserving time to render the service, and that in and of itself makes you unavailable to make revenue in, during those times, and you've reserved that time to render those consulting or coaching services, it's a great practice to collect that payment upfront. And that way you are not having to chase invoices, or, badger the client throughout the coaching relationship, because those are two different types of conversations, and it could potentially affect your, coaching relationship and the container that you're creating there. So thanks again, Judy. I appreciate that. Okay, so we talked about incorporating something about pausing your contract or billing for work completed, and addressing what happens when a client is non-responsive. Now, if you have questions about any of these clauses that we're discussing, or really anything that we're talking about here, please feel free to drop it in the chat. I do want to encourage you to ask questions and to be open. However, please don't share anything sensitive or confidential in the chat. This is, of course, a public forum and a public space, with attendees checking in from across the country and even around the world. We have a few people outside of the US, but please be mindful of that. And then, of course, another gentle reminder that I am not able to provide direct legal advice to your specific situation within our current setting. And I encourage you to consult one-to-one with a lawyer in a private setting if you do need legal advice related to your situation. So welcome again, and please feel more than welcome to share your questions in the chat as we continue and go through. Okay, so next thing we're going to talk about is ensuring that you have the rights to keep things moving. Okay, so like I mentioned earlier, there are some situations that you'll want to make sure you're getting consent from your client when it comes to specifically featuring the work that you're doing together, featuring them as a part of your portfolio or your case studies, or maybe a testimonial that they provided to you. If you want to feature their photo or their name, that is considered their likeness, and they have the right to that. They have the right to consent to that. They have the right to say, no, I don't want you to publish my photo on your social media, or publish my story on your website, or, feature our call on your YouTube channel, which I can't imagine anybody would feature, recording of a call on a YouTube channel, but the client could consent to that, and that could be really cool, actually. But the point is, don't do it without their consent. Make sure that you have the consent of the individual before you feature them in anything on your website, on social media, their testimonial, etc. Now, this is something that you could get the consent for later on. If it wasn't in the contract whenever you sign the client, you could get their consent for it later on, and just get it in writing. It could be, via an email, or you could send a separate written agreement for them to, formally consent to. However, it's also something that you could collect in your initial contract if there is a project that you're planning to work on. And, we have a variety of people here that have registered for, today's live session. Many of you are in the professional coaching and consulting space. So you might be working with an individual on personal coaching, and a different attendee today might be working on a design or visual or written type of format of creation, of intellectual property creation. And so let's say you are a designer developing a brand, and that includes, the entire brand identity and all the visual aspects of it. You might want to feature that on your portfolio. Let's say you are a coach who is, in the health and wellness space, and you're working with a client to transform their, maybe it's something related to their personal health, or something as specific as, their fertility. And so maybe you want to feature their story and their case study, where they were when you began working together and where they are now after working together, and, featuring the transformation that they've experienced throughout that time, which hopefully all of you here are able to help and support your clients achieve positive results through your work together. And so let's see. This is something that I've seen some individuals disregard, and they find themselves facing hostility from past clients and just like negative feelings from past clients, because the past client feels violated, that their story or their face and likeness was featured for commercial purpose without their consent. Most people are totally fine with you featuring them on their website, and in fact are excited about that possibility. But when it's done without their consent, it just doesn't feel good. And so it's something to be mindful of, and something that you can just collect at the time of their initial, contract signing, and, not have to revisit at a later time if that's something that you would prefer to streamline and avoid having to revisit that. So I would love to hear from anybody that's here live. Have you ever found yourself in a similar situation? Have you ever found yourself either the individual who shared the testimonial and then realized that the client did not consent and had to, do a little damage control? Or were you on the other, the flip side of it? Were you a client who was featured and then realized that you were on their website or on their portfolio, or your photo was used in a testimonial and you did not consent to that? I'm curious to hear from you all. Otherwise, we're going to keep moving, and we're going to move on to our final clause. I'm going to take a sip of water really quickly. And then we'll continue. And so the next thing we're going to talk about is Yes, we will continue to the next part of ensuring you have the rights to keep things moving. So the first thing we talked about were portfolio and case studies. So those are those testimonials featuring the work of the project, featuring details about the clients, etc. Even if you do so anonymously, it is still encouraged to get their consent. And if you do decide to do it anonymously, it's possible to do so without consent if you change enough from the story where it's impossible for anybody to identify them. However, if you are working personally with an individual, as opposed to if you're working with, corporations or, companies are your clients, as opposed to an individual as your client, when you're working with individuals, it can be very personal. And so it's generally encouraged to get their consent before using them as a case study. And then the next thing to make sure and to consider having in your contract is consent for your recording sessions. So, or rather recorded sessions. So if you're recording client calls and maintaining those recordings, then it might be relevant in your jurisdiction. It varies from jurisdiction to jurisdiction. Some jurisdictions, it's perfectly fine for one person that is party to the recording to consent, and that would be you, of course, the person recording. But in some jurisdictions, both parties must consent to being recorded. And so this is something that you can also include in your contract and just gather their consent. And that way you can just know I have that covered. I'm not having to, you know, get their consent on each and every call or each and every time that we're meeting and that I'm recording our sessions. Okay, so, and you can see, I'm gonna just leave it here just in case I cannot recall if that bottom text was covered by my photo in the corner. And I'm gonna check the chat. So let's see. Okay, cool. So we'll move on to the next section. And before we move on to the third one, I want to share a bit of encouragement with you because I know that the content of this session and what I'm sharing here is not exactly, the simplest stuff, and it's not exactly the most exciting or sexy stuff. I totally recognize that, I know, but it's very important stuff. And the fact that you're here, I mean, I applaud you for being here. You're just doing awesome as a business owner if you are here today, because that means you recognize that, okay, let me be proactive and take some steps to actually protect myself and what it is that I'm building. And I want you to know that you can do this. Even if it feels a little scary or a little confusing or maybe even a little intimidating, you are totally capable of doing this. Like I said, you don't have to go to law school to figure this out. You don't have to hire an expensive law firm to get all of this in order. You can do this. You're not the first business owner to approach this, and you won't be the last. You are capable of doing this. It just requires that you take those steps and be diligent. Do your due diligence early on and gather the information that you need to make the best decisions for you and your business. No two people or two businesses are exactly alike. And so it is important for you to have a foundational understanding so that you can navigate in a savvy way when it comes to being a business owner and making decisions as it relates to your business. So you can totally do this. The fact that you're here speaks volumes, and I just want to give you a round of applause. And then we're going to move on to the next one. Somebody shared in the chat, I've been featured without my permission on at least 2 occasions. I lost trust in those people. I didn't work with them further once our initial contract was complete. I'm so sorry to hear that, Judy. My goodness, I've heard many people over the years tell me that they have been featured without their permission. But I don't know that anybody has ever told me it happened to them more than once. So I'm so sorry to hear that you experienced that. I totally hear you. And I think I would feel the exact same way if somebody featured me without my permission. I would lose trust in them and, feel taken advantage of to a degree. And so I also would no longer work with them after our initial contract was complete. And, maybe had you worked, I'm curious if you had, enjoyed your work together. Aside from that, had you been approached by that individual respectfully and your consent requested, would you have agreed to be featured on their website or, in their case studies? Your answer might be yes or no, and, no pressure to reply or share that. But, it's something to think about is had that company asked for the consent, then your feelings towards them and your experience with them might have been totally different, and their reputation would not be negatively impacted, because this is something that can absolutely have a negative impact on your reputation if you are a business owner or a company that is featuring people on your website without their consent, using people's likeness without their consent. That also brings into question the validity and credibility of the content of the case study or the testimonial if it was published without their consent. So it's an easy thing to avoid and just have a red line that you don't cross. Nice. Judy said, if I was approached, I would definitely agree. Totally. I hear you. If your experience was positive, then you want to, provide them with express your gratitude to them. And that can be one way to express gratitude as a client. Absolutely. So, okay, we're going to move on to the final section of today's session. And that is all about deciding how your creative work is used and valued. And so we talked about earlier about intellectual property. What is IP? Those are the rights that you hold as the owner of those intellectual property assets that relate to how you use the content, how it's allowed to be used. Is it being used to profit from? Is it something that only you have exclusive rights to the use of, or are you providing access to others to use your intellectual property? And so intellectual property assets, these are intangible assets. You can't physically touch them, like a car or a house or a piece of land. It's something that's intangible. You can't physically touch it, but it certainly holds value. And these are specifically your trademarks and copyrights. And so if you've attended past sessions of mine where we talked about the difference between trademarks and copyrights, I'll give you a quick overview right now. Imagine that your offer or your business is a box, and the box has some wrapping and packaging on the outside, and then it has something on the inside. You don't know what's inside yet, but on the outside, you can see the name of where it came from, a logo, a tagline, some colors. Those are your trademark assets. They identify the source of the products that are inside. Whatever is being sold, it identifies where it came from. Those are your trademark assets. When you open the box up and you look inside and you see the contents of the box, those are your copyright assets, and it's literally the content of your business. Those are your original works of art and authorship. So those could be written works, visual works like photography, videography, audio works like podcast audio, music. I mentioned written works, and that covers so many different forms of writing, whether it's a book or a physical book or an ebook. Maybe it is blog posts on your website. Maybe it's emails that you're sending to your email newsletter list, or really any written work that is being produced and published. You have ownership in that and the rights to decide who is using it and when. And so outside identifies the source. They're on the packaging, or if it was a shirt, it would be on the hanging tag. Those are your trademark assets. Your copyright assets are those rights in the original works and authorship that you are creating. And so in your contracts, you should be stating how your client can use the content you're providing them access to. Maybe you're providing them access to content in the form of a course or a coaching program. Maybe you're providing them access in the form of, a workbook or PDF. Maybe you are providing them, maybe you're creating content within the, the client relationship. So perhaps you're a photographer who's capturing images, or maybe you're a videographer who's capturing video. Maybe you are a copywriter who's creating copywritten work, or a visual artist and visual designer, and you're creating, logos and visual designs. Perhaps you are a consultant in HR and you're helping develop handbooks for their employees and their staff. Maybe you are, an operations specialist and you're helping develop different internal documents for their SOPs and different, documents for tracking and workflow and operations related things. And so it can look a lot of different ways depending on the type of relationship you have with the client and what it is that you're selling the client. The bottom line is that you want to make sure that you are clearly stating in the contract, are you transferring ownership of what it is that you're creating? So what you're creating with your clients are likely copyright assets, written works, audio works, visual works, if you're creating IP within your client relationship, or maybe you're providing access to your own intellectual property. You want to make sure that you are clearly stating in the contract who is going to own it at the end of this contract. Sometimes the client wants to own it. Sometimes the client just wants to use it. Sometimes you might want to transfer ownership, or other times you might want to give them a very generous commercial license to use it in the way that they intend to use it. And a lot of photographers and visual artists and designers will retain ownership of their works and just provide their clients with a broad license, a very, generous license for them to use it commercially. And so that's up to you to decide. And it's up to you and the client to decide, honestly. You and the client can decide, okay, is this something that they want to own, or are they happy with maybe your default contract and your default policy is I maintain ownership. And then if they want you to transfer ownership of those works to them at the end of the contract, then the price needs to reflect that, of course. So make sure you're being mindful of that. Now, I mentioned reserving ownership. If you want to retain ownership of that IP and just provide the client with the license to use it. And so this could look like maybe you're within the contract, you're creating the content, And so you want to share a license, as I mentioned, with the client. You could certainly do that. Or maybe this looks like this is content that you already had created prior to your relationship with the client, and that you are just wanting to provide them with a license to use it, to access it. Maybe that's for a certain period of time, or maybe that's, forever and for always. Whatever that looks like, you get to decide, and you can and should put that in your contract. I'm going to scroll a little so you can see the bottom of this. Sorry, I had not accounted for my photo in the corner. I thought it might be on the other side, but I should have checked that. But we should be just fine. So yes, this is something to keep in mind is, okay, how am I going to allow for them to access this content? What are my, what are my intentions here, and what are their desires, and how can we get on the same page and put that in writing so that we're both clear on how I'm going to allow that client to use the content we're creating in this contract, or maybe it's content that you brought in and was already created. Okay, cool. So let's move on to our next slide. And I want you to keep this in mind. And I said this already in a different way, but you have the right to decide what happens to your IP. Okay, that is up to you. The ball is in your court. It's, it's a home game, if you will. You get to decide. Your IP is yours. And so when you leave things to be somewhat implied, or for assumptions to be made, it makes the water is murky at that point, and it's not clear where your rights begin and where yours end, and where theirs begin and where theirs end. And so be really diligent and I would say assertive and very clear about what rights the client has to the content you're creating together. If you're not putting that in writing in your contract, you're doing yourself and your business a disservice. And you're also doing your client a disservice because they are unclear and could find themselves facing a legal issue that you also find yourself facing, and that could have been avoided by both of you had it been in writing and had it been agreed to. Okay, so the importance of client contracts. Like I said, if you're here and you're watching this, and you are probably fully of the mindset that having a contract in place with each and every one of your clients, each and every one of the relationships really that you have within your business. Today, we're focusing specifically on client contracts, but we have relationships with our business partners. We have relationships with our employees. We have relationships with our vendors and contractors that we hire as businesses. You also have a relationship with the people on your email list. If you collect email addresses on your website, they have a professional relationship with you. You have terms that govern those relationships and the laws that govern those relationships. And so today we focused on just client contracts, but I want you to know that those relationships are, like I said, the foundation of your business. And without those relationships, you really don't have a business. And so you are in the best position to strengthen those relationships. You are in the best position as the business owner to get clear clauses in place for especially your client relationships, because that is likely what you're going to spend most of your time operating within as the business owner and as a professional service provider, is either talking to your clients throughout the marketing phases, throughout the sales process, and throughout delivery of the service to the client. And so really be mindful of this, and take a close look at your client contracts before the end of the year. Make sure that you are taking steps to, really review the quality of your contracts and your clauses. Make sure that it's accounting for everything that you anticipate could come up in the client relationship. Again, you are the best person to identify those and make sure that they are in writing in the client contract. And so take some time to think through, the past year. What issues came up with clients throughout your work together? Is there possibly a way for you to put those situations in writing and create a policy around that, so that if that situation comes up again, you and the client both have a clear roadmap of how you're going to handle it? As opposed to if you don't address, for example, something very simple and fairly common is a late payment policy. If there is, if you're operating on payments of milestones or monthly payments, what happens if a client is late in paying? if you don't include it in the client contract, that leaves it up for, negotiation in real time, which you never want to negotiate with a client in real time after you sign the contract. You want to do all that negotiation before the contract is signed. If you don't address it in the contract, you leave it up for, again, negotiation, and also anything could happen at that point, and it might even end up negatively impacting the client relationship as a whole. And so just ensure that you are, like I said, taking time to reflect on the past year. What situations came up? Okay, can I create a policy to include in my client contract that can help us navigate that similar situation if it were to rise with another client in the future? If so, do that, and do it sooner rather than later. Do it before you sign your next client. And that way you can strengthen the foundation of that working relationship. Remember, your client wants for your relationship to end well. Your client wants for they want themselves to receive the outcome that they are hoping for in working with you. And so the more confidence you can give them to have in you, the more security you can provide them with when they see a roadmap that they're going to follow and that you are going to follow together throughout your work together, that is only a positive contribution to your working relationship. And again, it provides them with, that confidence in you, and just knowing that, okay, I am in good hands and I can trust this professional to, move forward and achieve the outcomes that we are agreeing to achieve with one another. Prathima says, this has been so helpful. I already know a few things I need to add. Awesome. I'm so glad to hear that. Yes. And this is a great time to do that because it's, the end of November. You can totally still be pitching and signing new clients between now and the end of the year. Absolutely. That's totally possible. And I know many people are continuing to do that. And also, many people are taking this time to prepare for 2025 and for the new year, and to begin approaching new clients, prospective clients at the top of the year and in January. So right now at the end of November is a great time for you to take a look at your contract and see, okay, how do I want to structure my client relationships going into December and going into 2025? And what kind of understandings do I want to have in place? What kind of policies do I want to have in place? And yeah, so I'm so happy to hear that. Okay, cool. Veronique said, the pause clause is brilliant. Thanks so much for your insight and expertise. You are so welcome. Thank you so much for being here. I'm so glad that you all attended today and made the time to join me today. I feel really, really passionately about business owners legally protecting themselves and getting those protections in place so that they're not having to have it just hang over their head throughout their entire business journey, and just every week having to think about, okay, well, am I good? Is it like, am I in the clear? Do I have in place what I need to have protected? And worse than that, I feel, actually maybe equally as bad, is having a client contract that you don't feel confident in, and then it's subconsciously you're holding yourself back from signing new clients because you don't want to send that contract out and increase the surface area of, just whatever you imagine could negatively happen in your business. And so it's something that I am very happy to hear that you all are, thinking about this and taking action to legally protect your business. And I want to encourage you to continue to do so. Because this is totally possible for you. And this is a way for you to positively impact your business. And I'm happy to continue to provide these resources and hosting live sessions like this. And I appreciate all of your feedback. And please, I'm open to your questions as we wrap up in a few minutes. Judy said, this has been wonderful. Thanks a lot for helping me continue to be smart, organized, and professional. Oh my gosh, yes, that's the goal. That is the goal, to be smart, organized, and professional. And you're already smart. We're all a work in progress when it comes to being organized, and as well as being professional. Being professional, there are certain steps that we can take to make sure that we are, quote unquote, professional on an automated basis, where we are, sending out our contracts in a professional manner. We're presenting our contracts and our proposals in a professional manner. We're maintaining professional communications. And you're going to see in the client contract audit checklist that I'll share with you, and I'll share that link in the chat in a moment. There is, another clause that that you can check for in your contract is around communication and how you communicate with your clients, when they can expect communication from you, where they can expect communication with you. Are you available for business communication in your DMs on Instagram or in your DMs on LinkedIn? Maybe not. I'm gonna guess probably not. Probably not the most efficient way and most organized way to maintain your client communications, but you want to be really clear about that with your clients. If they need to communicate with you, how? Is it in Slack? Is it in Voxer? Is it via email? Is it via a client portal in Honeybook or Dubsado? Whatever that looks like for you, put it in writing, and that way your client never feels like, well, they're not answering me because they haven't replied to my Instagram DM. They're not rendering services. Well, that's not, our services don't extend to every single online platform that you could possibly contact us on, because it's a little ridiculous when you say it out loud, isn't it? But that allowed, from the client's perspective, they are unclear as to how they can communicate with you when it's not in writing. And so, yay to being smart, organized, and professional. I'm here for it, Judy. And that is my mission for all entrepreneurs, and including myself and everyone here in attendance. And that is a huge part of what drove me to create Coaches and Company, was making client contracts and really all contracts and legal resources accessible for entrepreneurs. Because as I mentioned earlier, I totally recognize that not all business owners are in a position to invest in legal services and hire a law firm right off the bat, because it is quite expensive. And it does require a commitment of both time and money to create custom contracts from scratch. And then what I've also found over the years is that most business lawyers are not in a position to create tailored contracts for this business model in terms of selling a service online. When you're marketing, selling, and delivering a service virtually, things look very different in client delivery and in the client experience. And so accounting for those things in your contract is the smart thing to do. And so we also have our biggest sale of the year going on right now at coachesandcompany.com. You can save up to 50% on all contract templates in our shop. So if you know that you need to upgrade your client contracts, if you know that you need to, update the terms and conditions on your website, or maybe you have a coaching agreement or, a freelance services agreement, depending on what it is that you sell. If you know that you need to upgrade your contracts going into 2025, now is a great time. There's no code required. You can just go to coachesandcompany.com. And add the contracts that you need to your cart and complete your checkout, and then customize your contract within 30 minutes. And it's a beautiful thing. It is a beautiful thing. So please check that out. And then I'm going to share a link to the client contract audit checklist now. And I want to thank you all for joining me. Thank you so much for being here. Let me grab this link. And then, okay, Aine asked, Yasmine, how are the templates applicable to different countries? So our contracts are drafted by an American lawyer. I'm licensed in the state of Texas. I drafted these contracts, and they were also peer reviewed by other attorneys that are licensed in the US as well. So these contracts were created, again, by a lawyer that is licensed in the US. However, they are designed for the type of business model and the type of relationship and the different policies that you would have within a relationship like this. So we have customers and users of our contract templates all around the world. I actually need to I need to set a reminder to figure out how many different countries our customers are in, but it's multiple. And they love our contracts because our contracts account for the different scenarios and policies that you want to make sure you have in place when you are in a client relationship, a coaching relationship, a consulting relationship, an agency or freelance type relationship. And what we recommend for all users of our contracts, regardless of whether you're in the US or outside of the US, even within the US, we have 50 different territories, 50 different jurisdictions, for our 50 states. And so each state has its own business laws on the books. And so the best approach, in my opinion, is securing a contract template that is designed for your business model, for your relationship structure, whether it's coaching or consulting or freelance services or an online course or a live workshop, or, whatever it might look like, the way that you're working with your clients, and customizing that, filling out that template with your information, and that relates to your offer and the way that you're working with your clients. And then take that to a lawyer licensed in your local jurisdiction, whatever jurisdiction's laws are going to apply to your business. And it's likely where it is that you're operating, or where you formed your business entity, or your LLC or your corporation. Those are the laws that you'll want to apply to your contract. And so because there are, thousands of jurisdictions around the world, of legal jurisdictions around the world, this is like I said, in my opinion, it's the best course of action, is to secure a contract template like the ones we offer at coachesandcompany.com that are specific to your type of offer. Fill it out, follow the user guide, fill it out and customize it. And then if you want to take it one step further, take it to an attorney in your local jurisdiction, have them review it, provide you with those revisions or recommendations for revision, letting you know if it is compliant with your local laws. And that is the better option when compared to, should I go hire a lawyer, pay them, $2,500 and up to create a custom contract for me that might even end up being a general contract, because they aren't, deeply familiar with the nature of online services, selling personal coaching services, professional consulting services, freelance services, digital products and offerings, etc. So I hope that answers your question, Ain. Let's see. Veronique says or asks, what about a virtual service business with clients all over? Should we default to the laws where we are located? So that is the beauty of, sorry, y'all, I got distracted. I meant to get the link for our free checklist. So one moment, and I'll come back and answer your question. Let's see. Okay, hold on. Oh yeah, that's right. I saved it here so that I wouldn't have to look for it later. And yeah, there I was looking for it later. Okay, I'm going to share the link with you in the chat, all of y'all that are here live. And then what you'll want to do is click File and make a copy, and you will be able to, all right, there's the link. And you will be able to create a copy on your own Google Drive, and that way you can customize it. You can click the check boxes in the checklist and mark them off as you go through your client contract, doing your own audit. And let me know. I would love to hear from you. I would love to hear from you as far as how you enjoy the client contract and whether or not it was helpful. So feel free to send me an email, or you can send me a DM on Instagram at Coaches and Company, or at Yasmine Salem Hamdan. I'm in both inboxes. Okay, let me see a few more in the chat. I'm going to move it up to this in case anybody, you can check it out at coachesandcompany.com and shop our sale. Okay. Veronique says, yes, that's right. That was a question I was about to answer. What about a virtual service business with clients all over? Should we default to the laws where we are located? So I was saying that is the beauty of having that. I like to call it home court advantage, where you get to decide what law applies to the contract and to the relationship. So it's in your best interest for the laws of your local jurisdiction to apply, because then if you are needing to enforce this contract, or there's some sort of legal action that needs to be taken, you have that home court advantage. You can do that in your own jurisdiction. You don't have to travel to another jurisdiction. You don't have to hire a lawyer in another jurisdiction. Whatever is stated in the contract, that is the jurisdiction that applies, unless both parties agree later on that they don't want it to apply. So what I've seen in the past is I remember years ago, I had a client who she had hired a company to provide a service to her business, and they had a written agreement, but it was pretty questionable, if I remember correctly. But one thing in particular that I remember signals to me that it was not that great, and it was in particular that they did not address the jurisdiction. So they didn't state what jurisdiction's laws apply and govern the agreement. And so eventually, and it was prior to my communication with the client, all of this had happened before we worked together. Eventually what happened, as she told me, was the judge was not willing to enforce the agreement. They ended up going to court trying to enforce the agreement, but the judge looked at it and said, well, there's no jurisdiction. And there were some other issues with it, but jurisdiction, I remember, was one of the main things that the judge said, we haven't established jurisdiction. The agreement doesn't address that. We can't enforce this. And so this is something that can get your agreement tossed out entirely and you're not able to enforce it. And there isn't clarity around what laws apply. And so Veronique, you are in a great position to specify what jurisdictions laws you want to apply in your client contract. And so, yeah, you can default to the laws where you are located if that is where your business is doing business. I hope that answers your question. Aine, you're so welcome. Yay. Okay, nice. This is very helpful. I will establish jurisdiction. Perfect. Yes, super important. So I'm so happy to hear that. Prathima asks, any suggestions on asking for using testimonials or words or their name post-session? Like, is there a proper way? Is your written email approval enough? I would say, generally speaking, that written email approval is enough if you are asking, if they provided you with a testimonial and you ask in writing in an email, is it okay if I use it on, and I would specify where you're wanting to use it and where you're asking them to consent to you using it. So let's say, you're asking, can I use this in, on my website in a case study? And they say yes. But then you decide, I'm going to put their photo on a billboard and their testimonial on a billboard, which I can't imagine anybody here is going to do. But, for sake of our example here, hypothetical, those are not the same thing. That's not the same consent. Arguably, the client could, and maybe rightfully should, be unhappy with you and feel that they did not consent to their likeness being used in that way. So yeah, Prathima, I would say that it is possible for you to get their consent if you're like, hey, I would love to feature your testimonial on our website, or I'd love to feature your testimonial on, our online platforms that include our website and our social media platforms. That I think would be perfectly fine. But you want to be specific and you want to make sure it's in writing and that both parties are clear as to what is being agreed to. And yeah, it's totally possible to have a written agreement in email. It doesn't have to necessarily be, a formal contract in a PDF format that you're delivering for their signature, although you could do that. Okay. Hope that's helpful. Okay, so that's all for today's session. I hope it was beneficial to you. I hope you found this helpful. I'm so happy seeing your feedback in the chat, and I invite more feedback and your experience of today's session. If you found it helpful, if you found it valuable, totally open to hearing from you. And if you are someone who is needing to upgrade your contracts, now is a great time. We are having our biggest sale of the year at coachesandcompany.com. You can purchase any contract available, as well as our bundles are also all on sale. And so, yeah, check it out. And if you have questions, you can always send us a DM at Coaches and Company. We're also available via email at hello@coachesandcompany.com. But thank you all for being here. Thank you for joining me live, each and every one of you. And I want to encourage you today to take action in your business in a positive way. That might look like something related to legal. That might be something else. Each one of us is facing our own challenges and to-dos in our businesses. And so just know that you are totally able and capable of doing this. Just keep moving forward, keep seeking the information that you need in order to take confident steps as a result of confident decisions that you're making in your business. As a business owner, decision making is one of your main to-dos, as well as one of the main skills that we are always working on and either improving or maybe not improving. But I want to encourage you to continue to move forward, gather the information that you need, make decisions in your business that serve your business and improve your business and propel it forward. And, like I said, that might be legal related today, that might be related to something else, but just know that you can do this, and I am rooting for you, and I appreciate you being here, and hopefully we'll chat soon. I'll see you in our next session and also around the internet. All right. Bye, y'all.